Hello, welcome to topic 5 and our 6th week of contract law. You're technically halfway through this subject, at least quarter of the way through your contract study at law school. So yay you, yay me for getting there with you too. So what are we going to cover today? Well, over these series of mini videos, pay attention to what the objectives are. I think you'll be starting to feel a lot more comfortable now. So by the end of going through this topic, so these little mini videos and the class activities, I expect that you'll understand that there needs to be an intention to create legal relationships before a contract becomes binding. Actually, I think you already understand that because you know in order to form a contract, we need to have agreement made up of offer and acceptance. We need to have consideration, which is the price of the promise, and we need to have intention, which is what we're going to talk about today, and we need to have the element of certainty. Well, we already know that in order to have agreement, we need to have an offer that's capable of acceptance on its terms without variation, and that's a big part of understanding certainty. So we're actually really moving quite well through these ideas. And so really, I think you already understand that you need intention, and really we'll be looking at what intention means and when it might be an issue. We're going to talk about the fact that in order to identify whether intention exists or not, a court will use an objective test. Again, this is nothing new. This is something that we can even point to in the case that you're very familiar with, Carlisle and Carbolic Smoke Ball. It was the very words in the advertisement showing our sincerity. We have deposited £1,000 with the Whoopity Whoop Bank. That was taken by the courts objectively as demonstrating that there was an intention to be held to that promise. Our third objective is to make sure that we understand the ideas of presumptions, in particularly in domestic and commercial agreements, and how those presumptions are used in a modern era. Dave touches upon those in his intro video for you, and we'll take that a little bit further and understand how, subsequent to the case Ermogenes, which was part of your reading, really presumptions really just go to the onus of proof, which is a topic we'll discuss in some detail. And we'll think about intention not only in domestic, family and social agreements, but also in the broad context of commercial agreements. Hopefully you've done the reading by now. If you haven't, hopefully you've done it by the time you get to do the activities. So let me talk briefly about this kind of overview. So really, as a general rule, there's this idea that intention, which needs to be objectively identified, demonstrates a voluntary assumption of a legally enforceable duty. That's a principle that comes from the Australian Woolen Mills case, one that we come back to a couple of times over the different contexts, and we spoke about it quite a bit in consideration. So in identifying whether or not there is intention, the courts will take into account a range of surrounding circumstances, including the actions and the statements of the parties, as well as the terms of the documents. So Air Great Lakes and Easter Holdings is a really good example of that. It's not in your casebook, but it is in your materials, and your textbook talks about it in some detail. And you'll see from that case that the starting point is always the language and the context of the particular transactions. Parties can use express words to indicate whether an agreement is legally enforceable or not. And often you will see that in an actual contract agreement. It will, so that I'm using the word agreement there to being the noun, not the verb, the actual physical document that records the transaction. So often deeds will have very flowery languages like this deed witnesseth the intentions of the parties, but it might actually just be as straight, the purpose of this document is to record the intentions of the party to be legally bound to the following terms and conditions, blah, blah, blah. So when you have an express statement in a written document that's been signed by both the parties, whoopity-doo, easy peasy, no need to do anything more. But when we don't have that, we need to turn our minds to the question of whether there was an intention to be legally bound. So really what we're looking at is where there's no express statement. And the rule here essentially looks differently at domestic social family agreements on one hand and commercial transactions in the other. But since Irma Genus, the role of presumptions, actually, let me backtrack a minute. So traditionally, we've had these two sets of presumptions. So the presumption is if it's a social, domestic, or family arrangement, we assume that it's not intended to be legally binding unless the parties say so, and we can demonstrate something. And the presumption works the other way in a commercial agreement. So we assume that it is intended to be a binding arrangement where the parties are arm's length unless there's something that says differently. So since Irma Genus, the role of presumptions has become a lot more narrow. Generally, the role of the presumption really is to point out whose burden of proof it is. So in a social or domestic arrangement or agreement, the party who's seeking to prove that there was an intention to be legally bound is the party who needs to bring evidence to the court to that effect. And similarly, in a commercial arrangement, it's the party who's seeking to argue that there was no intention who's required to put that evidence before the court. What kind of evidence? Well, the factors that can be taken into account include the subject matter of the agreement, the status of the parties and their relationship with one another, and other surrounding circumstances. And we will talk about that as we move through, and we look in particular at the Shahid and dermatology group. Sorry, the word has just gone out of my head, the dermatological school of practitioners. We'll talk about that in about a minute. So I got a range of, then the other side of this equation, sorry, just go back to my map here. Why don't I actually use my little laser pointer to point it out? So the other thing that we need to look at is the effect of preliminary agreements, and in particular, look at the three requirements in Masters and Cameron, or the three options for determining whether or not intention exists. And along the way, we're going to think about some of the difficult issues, in particular honour clauses or letters of comforts. And we'll talk about agreements with government and preliminary agreements. So, what is intention? Whether the parties appeared to intend to create a binding agreement or not is relevant to the question whether a bargain has been struck and each party has paid for the promises made by the other. So intention is very closely intertwined with the idea of consideration. And when we talked about the reasons why consideration is a natural element or a required element for the foundation of contracts, many of the reasons that people involved in the activities in class came up with were deeply linked to this idea of showing the world, showing the court, demonstrating an intention to be bound. It has been argued that the doctrine of consideration provides the essential test. So the other side to that argument is we don't need intention if we've got consideration. And so it has been argued that it's unnecessary to make separate inquiry into whether the parties appeared to or intended to be bound. So the material element of intention overlaps somewhat with the other material elements of contract formation. Not all agreements will be enforced where offer, acceptance and consideration requirements are satisfied though. So it is important to look at intention, particularly in social, domestic and family agreements, where courts might take the view that the parties had no intention that their bargain would be legally binding.